Sometimes lawyers are categorized as either a pleader or a litigator. Well, the pleader is someone who is able to put into writing the position taken by the client on a particular issue pending before the honorable court. The litigator, on the other hand, is someone skilled in articulating it. Now let me ask, which one are you if you are a lawyer? A pleader or a litigator? Or, if given a choice, which one would you rather be? We have a very interesting topic today. Well, if you ask me, I cannot make a categorical statement if I'm a pleader or a litigator. I wish I'm good at both. But anyway, it's my body of work, it's the results of my efforts that would ultimately decide where I stand. But if I were to compare the two and make a determination which one is more important in law practice, being a litigator or being a pleader, I think I cannot make a straightforward answer, but rather provide categories by which we measure the worth of the pleader or the litigator in legal practice. My first category would be the obvious one, communication skills. The second one should be, well, the ability to think on the fly. The third category would be the ability to handle pressure. The fourth would be the commitment to endure and work in the long haul. And lastly, well, the love of the limelight. Now, let me begin with the first category, communication skills. Of course, this is obvious. Both litigators and pleaders should have excellent communication skills because that's what lawyering is all about, communication. But it's only the medium that differs. As for the litigator, he does his thing verbally. He appears in court, argues, makes manifestations before the judge. On the other hand, the pleader usually works in the silence of his office, making research, preparing the pleadings, doing the work behind the scenes. Of the two, I would say that both are necessary skills, the skills in pleadings and the skills in litigation to be able to thrive in the profession as a lawyer. If you put a gun on my head and make me choose, I would probably choose to be a pleader because the pleader doesn't grow old. The litigator has a very short shelf life. In fact, if you look at the big law firms, the senior partners don't litigate anymore. They assign the litigation to the younger associates or the younger partner. On the other hand, if you are a pleader, no matter how old you are, you can still do the pleading because you work on your own and you are judged by your result, by the pleading that you produce. And I think the older you get, the better you write because your research and your stock knowledge continue to grow as you advance in years. And pleaders have I'd like to think that pleaders have no retirement age. As long as you can write even in your deathbed, you can produce pleadings, then you can still earn some good money. And besides, but in my own observation, everybody, especially the younger ones, would love to be litigators. The job of being pleaders is often relegated to those who are the silent type, the introverts, the less outspoken members of the firm, because sometimes litigation would require you to show some personality, some character. But if you are shy or you are not very adept at communicating, you would better be off as a pleader. And then the second category that I could think of, the ability to think on the fly. This is very important, especially to the litigator, because the litigator works on the spot. he is doing his thing on real time right in front of the judge. So the allowance for error is very slim, and the time given for the litigator to make judgment calls and to make decisions and to come up with something smart, something witty, those things need split second decision, a high level of alertness and presence of mind. Whereas on the part of the pleader, you can take your time. After all, you are not appearing before the judge. You are right in front of the computer making your pleadings. So the requirement for you to make split second decisions or to say something smart in a heartbeat is not really imposed upon you, because there is time for you to think and to evaluate your actions, because you are not in the presence of a judge, but you are working in front of the computer in the silence of your law office. So yes, in this category of the ability to think on the fly, that demand is greater on the part of the litigator, precisely because of the nature of his job and the kind of an environment in which he is working. The third category would be the ability to handle pressure. Both the litigator and the pleader deal with pressure, because deadlines are always the hardest things to overcome. Time flies so fast, and before you know it, you are already out of time and you are finished or not finished, patch your papers, so to speak. But on this regard, with respect to the demands of rising above the pressure situation, this is more often imposed upon the litigator, because when you are in an actual trial and you happen to be litigating in front of a very strict judge, the pressure is really sometimes overwhelming. Imagine you are arguing before the judge against your opponent for your client and in front of everyone else in that courtroom. Usually courtrooms in the Philippines are crowded. Most of the time, the courtroom is a pressure cooker. If you are the nervous type, if you are easily rattled, then maybe you are better off doing the pleadings instead of litigation in court, because litigation can be a very stressful job. So yes, with respect to the handling of pressure, well, this imposition is greater on the part of the litigator more than the pleader. The fourth category would be the commitment to endure and work the long haul. Definitely, this is something that the pleader would have to contend with more than the litigator, because litigation, for all the pressure and tension and stress that it brings, only lasted 1-2 hours at the most, but the writing of the pleading takes so long. In fact, it's one of the reasons that I hate doing pleadings. Sometimes I'd rather go to court and litigate than prepare pleading, because it takes so much time. You have to research, you have to sharpen up your vocabulary, you have to maybe ask people. The preparation of the pleading takes a lot of time, because you are concerned so much about the content, about the length of your pleading, and also the way you put it together, the structure of the pleadings that you will present to the court. It is very complicated sometimes. The task is voluminous sometimes, especially if there are so many issues to discuss and so many documentary evidence that you need to explain to the honorable court. So yes, maybe the act of litigation or going to court and arguing a case may be more stressful, but it only lasts, let's say, 1-2 hours at the most. But when it comes to the preparation of pleadings, it takes maybe weeks, even months, in really difficult cases. So if you are a pleader, there is greater expectation, or there is greater imposition upon yourself to really maintain the commitment to persevere, to endure, and to work the long haul. Finally, as to our last category, well, for the love of the limelight, I would say it is something that apply more to the litigator than to the pleader. Maybe we are carried away by media, by what we see in the movies, by what we see on the television, that lawyers have to go to court and show their brilliance. So somehow that perception is imbibed into people, that when they go to court or when people become lawyers, their first intention really is to go to court and imagine themselves doing well, to make a good impression upon the judge and everybody who watched the trial. So in order for you to become a litigator and to be really good at it, there has to be a certain attraction for being in the limelight. I know some lawyers who really enjoy the attention they are getting, the chance to show how articulate they can be, to show how passionate they can be in defending the client's cause. And I find nothing wrong with it, because without that motivation, without that love for the limelight, then I don't think the lawyer would continue to subject himself to the stress and the pressures of litigation. So yes, there has to be a certain amount of love for the limelight for a person to be continuously committed to the act of litigation. On the other hand, if you are a pleader, usually these are persons who don't enjoy being on the spotlight, people who are not comfortable speaking in public, people who may be introvert, so they would rather work in the silence of their office than go to court and argue and risk being admonished by the judge if they don't do their job well. I would say that in this comparison of litigators and pleaders, I don't categorically say that one is better or more important than the other in the scheme of things. To each his own. If you can litigate, then by all means go to court and litigate. But on the other hand, if your strength is on writing and making pleadings, then that's where you should persevere. That's where you should find your place under the sun. Ultimately, if you really want to succeed as a lawyer, you have to embrace both. You have to be putting in a lot of hard work and effort to be good at litigating and also to be good at pleading. So maybe that's just about it for this vlog. I hope you enjoyed it in the same way as I really had a good time discussing this particular topic with you. Maybe you could spare some time to comment or maybe like and share, the usual, you know the drill. And hopefully I'll see you again in the next vlog in this YouTube channel. It's about lawyering and the lawyer. It's about writing and the writer. It's about dog in the courtroom. Salamat po.